Good morning, everyone. Thank you for joining us today. My name is Edward Johnson, Vice President of Construction Risk here at Bender Insurance Solutions. By way of latest breaking news, Bill did see his shadow, so we will have 6 more weeks of, hopefully like 6 more feet of rain. So I want to thank you for joining us today for our presentation on construction and contract and employment law updates for 2023. Some housekeeping notes for those of you joining us virtually. If you have any questions during the webinar, please feel free to type them into the chat box or the Q&A section. For those of you here in person, feel free to ask questions as they come up. We'd like to keep this interactive experience with our presenters and be available to answer your questions along the way. At the end of the presentation, we will be sharing any other questions that might come up for our speakers, as well as opening up to our in-house attendees for more Q&A. We want to be conscious of time, so if we don't get to answer all your questions, we will gladly reach out individually after the webinar. Those of you joining virtually are in listen-only mode and will remain muted throughout the presentation. This session is being recorded, and at the conclusion of the webinar, the recording link will be made available, as well as a copy of the slide deck, and that'll be forwarded to you. We have some incredible experts sharing with us this morning, and I have the pleasure of introducing them. The first portion will be on contract law updates, and that will be presented by Scott Alexander and Ken Schumacher of Murphy Austin Attorneys. We'll then take a brief break, and the second half of today's presentation will be presented by Aaron Silva, also with Murphy Austin. Scott Alexander currently serves as the managing partner of Murphy Austin. Scott practices business and commercial litigation throughout all California state and federal courts, with a primary emphasis in construction and real estate litigation, public contracts, and complex contract disputes. You don't handle the simple ones. Okay. Scott received his JD with distinction from the University of the Pacific McGeorge Law School in 1997. Prior to receiving his law degrees, Scott facilitated municipal finance transactions, drafted related legislation for the California Housing Finance Agency. He graduated from Rhodes College in Memphis, Tennessee, with a bachelor's degree in business administration.
And he went to school with the Supreme Court justice.
And he went to school with the Supreme Court justice.
Yeah, Cody Barrett was his classmate.
So. All right.
That's amazing.
She's a little more skilled than Scott.
Gonna pull the Supreme Court card. Mr. Schumacher his practice focuses on all aspects of general and civil litigation with an emphasis on construction law, which includes the representation of contractors, developers, owners, design professionals, contracts, and real property disputes, business and commercial matters, and insurance coverage and litigation issues. Ken's construction practice includes contract, drafting, negotiation, bid protest, project consultation, and claims advice. Ken received his JD from Boston University School of Law in 1995. And while in law school, he served as an articles and book review editor for the Boston University Public Interest Law Journal. Ken graduated from the University of California, Berkeley in 92, and with a bachelor's degree in history and political science. And he knows everything about sport. Aaron Silva, also a partner with the labor and employment law practice at Murphy Austin. He has an extensive background defending employers before state and federal courts and several administrative boards, including the National Labor Relations Board, the California Division of Labor Standards Enforcement, the California Workers' Compensation Appeals Board, the California Unemployment Insurance Appeals Board, and Cal OSHA Appeals Board. Aaron was awarded his JD from the University of California Davis School of Law. Prior to joining Murphy Austin, he worked for both Cal OSHA Appeals Board and the California Public Employment Relations Board. Gentlemen, thank you for joining us this morning. And with that, I will turn it over to fine folks.
Thank you, God. I did not realize how
That was the short version.
how horribly boring those bios were. Our apologies. We'll have to do spice those up for next year, Edward. Well, welcome everyone. You guys must all be gluttons for punishment here, tuning in at early February at 9 a.m. to listen to a bunch of lawyers drone on. So bless you all, but we're very glad you're here. And you want to?
Yeah, just
So we want to thank our friends, obviously, the vendor insurance services. We've been doing work with them for many, many years. They're obviously excellent at what they do. We typically have given this presentation almost every year, I think, other than maybe COVID year, but nonetheless, that's something we really look forward to. Again, we have Aaron, who's our labor and employment partner. Just for contractors, we work very closely with Aaron. Scott and I do the construction side of it. Aaron does the labor and employment. We defer to him on those issues, so I'm sure you're gonna enjoy hearing from him in the second half of our presentation. And our firm is located in downtown Sacramento. We're 34 lawyers now, full service. We do construction, labor, corporate, real estate tax. We're kind of set up to help companies. And there are some clients here in the room and online, so we appreciate you guys very much. Really to start out, and what we're going to talk about today are just the new construction, employment, and labor laws, and also we're going to talk about some of the construction cases that came down in 2022. Sometimes we do this presentation, there's all sorts of great changes in construction laws. There's changes in lien laws, indemnity. Not this year. This was a pretty boring, benign year. We're going to go through them, but nothing that I would say is earth-shattering.
Which is good for contractors on the construction law side. Now, I think Aaron may have a different take on what has been occurring on the labor and employment front, but at least on the construction side, yeah, this has been it's been a pretty benign year, as Ken said, as far as legislation and new changes.
Yeah, and that's a good thing. Sometimes the legislature, they don't get it right. No offense to them, and they don't truly understand your industry. So it's good. Also, for these types of seminars, we like to be interactive. If you just want to listen to it, maybe Scott and I have time, 45, 50 minutes, you can do that. That's great. But if you have questions, war stories, anything that pops into mind, we'd love to have interaction with you guys.
Well, and guys, something I wonder about, what other recent changes have they become more stringent, or has there been the evolution of previous changes that have become more prevalent in practice?
Like enforceability type issues. Yeah, so whether or not state agencies are actually enforcing the law.
Yeah, we'll touch on those. Right. That's how.
All right.
Okay, so why don't we begin? So this morning, obviously, as Ken said, we're going to start with new construction laws and then morph into talking about a few of the more important construction cases that came out. And then after break, we'll turn it over to Aaron on labor and employment updates. Okay, so new construction laws. So before we start, obviously, there's more going on than just listening to the lawyers this morning. So did you know that it's National Tater Tot Day today?
I think tater tots are underrated. Do you guys agree? Very underrated.
And then I think what everyone does know is, Punxsutawney Phil came out this morning. He saw his shadow as Edward reported to everyone. So we got more winter coming, but it's also National Groundhog Day anyway. So we've got a couple of significant events going on today. All right, so let's start with some of the changes, and a couple of these will be some high level comments. First, every 3 years, the Building Standards Commission issues updates to the California Building Code. Very, very exciting, we know. Well, this is one of those years. So beginning on January of this year, every city is required to comply with in their contract documents the 2022 code that's been issued. For contracts that were issued, projects let before, I think it was December 22 of last year, the 2019 edition can still be followed. And we did provide a slide. We won't go through all these. There are a couple notable changes here that may have some impact flowing through. We think of maybe some contracts and some work that's going to be coming up. One of the important ones, there's now a requirement for automatic sprinkler systems in parking garages. So that's new construction. Also likely is going to be retrofits and remodel remediation work in parking garages. So that's going to have some cost impacts. A couple bullet points down in elevator shafts, there now needs to be essentially areas where there's access for air to come in and out. So gases and smoke and contaminants can move through. So in the event there's a fire or an event, that you don't have essentially the shaft serving as almost an internal bomb, if you will, in a building. Because unfortunately, so many of the buildings here in California, they haven't had remodel and renovation work done. There hasn't been updates in elevators and hoistways. And I think probably and if we have an opportunity to scan through here, the last bullet point, there's now a requirement for 10-foot candles of illumination and exit stairways and access stairways, which had been a lower standard previously. Now it's a little bit higher standard, so there is more light that's going to be required in those pathways. Staying on building codes, another requirement that will be coming up in the next 3 years. In the next code, the commission has been tasked by the legislature to adopt standards to require the installation of charging stations in various existing structures, which is going to include multifamily projects, hotels, motels, and certain non-residential developments, commercial facilities during remodels and during retrofits. So essentially the Tesla charging stations and the charging stations you see, there's now going to be a requirement as we move through the next several years that when buildings are remodeled, you have electric charging stations in those facilities.
Is it some sort of ratio of parking spaces or something like that?
You know, Greg, they haven't come out with what the standards are going to be. I suspect it's going to be a combination of, depending on what the area is, because they have the statistics, and then drilling down to the type of building usage, and then drilling down to you know, what the parking ratio is. So it's probably going to be some combination of that. But sure, it's going to be difficult and it's going to be expensive for owners, but opportunities for contractors as we move forward. And I believe I think it's going to be the last building code piece of legislation that we'll talk about. I think applicable, especially to us in the area we live with in California, with the fires, wildfires, and some that have now been beginning to encroach into residential areas as well. The next building code is going to require the state fire marshal to propose building standards for fire resistance in certain occupancy categories, different types of buildings, depending on the area of susceptibility to fires, whether the zones are rated very high, or moderate. So there's going to be, we anticipate probably the next 3 to 6 years, some relatively stringent fire resistant standards that are going to be included in non-residential buildings in fire prone areas, which again is going to be increasing owner costs on projects as we move forward.
And that's going to be significant.
Staying on the fire issue, also a recent legislative change, which, and this one actually I think is, again, another significant one given the area that we're in. I'm sure many of you have driven through Highway 50 on your way up from Sacramento to Lake Tahoe, and we've seen the very unfortunate remnants of the fire on the Phillips area and before you drop into the basin. Well, that fire, but I think for the last decade, many of the other fires, in particular the one in the Napa area, has really allowed a lot of fraudulent activity to kind of raise its head. There have been a lot of individuals who represented themselves as being contractors, represented themselves as being affiliated with contractors or entities, taking money from unsuspecting individuals who live in rural areas to do wildfire cleanup, and either done a substandard job, have made conditions worse, have not remediated things, have left dangerous contaminants, or have simply taken money from individuals and just left. So the legislature is now moving forward to require that entities who are going to be involved in wildfire cleanup pre-qualify. most of you on newer contractors understand what the pre-qualification process is. That's now going to be applicable to all who are going to be involved in wildfire cleanup. And the next, it's a Caltrans piece of legislation. So this is AB 1037, and I liken this to Caltrans thinking, hey, we're going to get into the 20th century now. So AB 1037, it's essentially Caltrans's representation that they are going to work on implementing digital construction management technologies in its projects. And you may say, what's a digital construction management technology? Well, that's defined in the legislation, essentially being cloud-based digital storage for project management documents, plans, specifications, RFIs, change orders, communications. And you're probably thinking to yourself, yeah, we've been doing this for a decade or more in our business or our projects. Absolutely. But Caltrans has given themselves until January of 2029 to implement that. So they're going to be with it very, very soon.
29.
Yeah, 29 is when they're going to have that implemented. So for those of you who work on Caltrans projects, it's coming. Oh, it's coming soon.
Can't wait. All right. So now we're gonna jump in a little bit into some changes on public works legislation. And the first one is AB 1851, which amends the labor code. Probably should have Aaron present on this, but I will give you the summary of this. This has to do with the definition of public works for prevailing wage. And if you guys remember some years ago, they kind of expanded that definition. It was the concrete mix companies and some others.
Yeah.
And they also included hauling of refuse from public works projects. Well, now they've expanded it further, and the bill says that public works is also includes on-hauling of materials used for paving, grading, and fill into a public works site if the individual driver's work is integrated into the flow process of construction.
Well done.
What does that mean? We don't know, and that's all the statute says. So we don't have any real clear definition, but just a heads up that they are expanding again a category of entities for who have to pay prevailing wage.
Wouldn't any concrete or gravel, wouldn't any truck be in the flow process of construction?
You would think so.
You're delivering materials that are immediately going to be used.
That are going to be integrated into the project.
So there was a line of administrative decisions about this concept years and years ago. So like the example is if the truck came in like immediately incorporated into the project, that was part of the flow. Whereas if they just dumped it, right? And then later on someone else came and got it, that was the distinguishing factor. I don't know how this is going to be interpreted, but it is flowing from that concept.
No pun intended. All right. So anyway, so just be mindful on your projects that there's more to it now prevailing wage. All right. Next is the AB 1867, which has to do with school projects. And projects are modernization projects under the Leroy Green Act. There's now a requirement for projects, current projects, and also some past projects, that you have to add faucet aerators and water conserving plumbing fixtures in all bathrooms. So if you guys have these projects, and especially the modernization projects coming up for the summer, I understand there's quite a few out in the street now, hopefully or thankfully. Just understand that there's not an additional requirement. It's that more efficient water systems in public bathrooms.
So like if you're touching anything, you then also have to touch the bathroom? Like because there's always been this lighting, they do the upgraded lighting and all that.
So I think it's just now, we got to go back through the bathrooms and update them too.
Is there more like detail to any of these, like, or like if this is something that directly affects you, is the only way to figure out if you're abiding by it is for somebody to come out and say, hey, you're doing this wrong, and have to go through some kind of litigation with someone like yourself to actually figure out what are the actual details?
Yeah,
I mean,
so
these very vague.
Yeah, so I printed out, so everybody can go online and you can find the statute. Okay, so you can type it in, and that's why when we do these slides, we have what the bill was, we also give you what the statute. And I will tell you that for this, and that's a good question, and you can't see this, there's a few sentences. So literally, when you seek definition, how it's gonna be enforced or application, sometimes your guess is as good as ours.
Yeah.
And so I guess that keeps us busy, but nonetheless.
And really, it'll be a shared responsibility, essentially between the designers who are gonna have to interpret what this means and if it's in compliance, and then pushing down to, the owner for approval, and then ultimately the contractor to have to, supply and install what the products are. So hopefully by the time it gets onto the contractor side, there's some definition in public facilities, 4 equals, or at least types of models, so there's some definition. But as Ken said, what in the bills, because you have a bunch of lawyers who think
Not contract.
yes, not contractors, who are essentially dictating how work is going to be done from the 30,000 foot level and not worrying so much about how things are going to be implemented as we move forward.
I think it's more of a design problem. I have the same
Yeah.
question as he, that will flush out in a bid protest, as far as on-site prevailing wage, and then it's up to the owner, if someone's low and you say, well, you're on-site hauler,
On the public work,
Yeah.
on the prevailing wage issue? No, that's gonna play out on the labor commissioner side, right?
Yeah, I think so, yeah.
Yeah, that's gonna be more of penalties and enforcement on the labor commissioner who's paying. So
So I'm saying if you don't list it as a prevailing wage on a bid, and another contractor protests that bid, right?
it's gonna be implied. Yeah, I think for prevailing wage, it's gonna be implied that you've gotta pay that regardless. So I think it's not, I think
So
it's
come
gonna
after the.
it's gonna be an enforcement issue.
Yeah.
But I think the other issue about the changes, that's gonna be more from the design side. So you're a contractor, there's changes in the law. The design does not identify this change, right? So that's your conflict, because you're saying, but chances are the way the public works projects are drafted, they're gonna hold you to the standards and the applicable laws. So you're gonna wanna raise that pre-bid and RFI or request for information on, if they're including this on a modernization project. So you can't just put your head in the sand and say, well, design doesn't have it. You have knowledge of it. All right. All right, well, this is an important affirmation of the law in that the public contract code. So a few years ago, they changed the maximum retention that can be held to 5% from 10%. And this law now makes it indefinite, that is the standard. And the exception is only if the public entity or governing body makes a determination at a public hearing that there's substantially complex and requires a higher retention amount than 5%. So they have to have some type of hearing and finding that we need more. So, David, we talked about this. Private works projects, a lot of owners still saying 10%, right? 10%, 10%. And I always write my comments back and say, well, industry standard is shifting, guys. It's 5%. Because on public works projects, it's 5%. So that there's a little bit of a, you got to understand that that's the way they've gone in public works. Doesn't mean that's the way private works projects are going to go, but that is the trend.
So, let's say you had a HUD project that has federal dollars, now you can say, hey, we want 5, not 10?
Well.
Because I think, a lot of the multifamily now is going like a hybrid, there's federal or state funds involved.
Right, so if state funds are gonna be involved, it's gonna trigger, if it's federal, may or may not, if it's solely federal, it may or may not trigger. There are certain federal laws that are gonna come into play there. Quite frankly, I don't know, I can't think of the last multifamily project I've seen that didn't have, if federal funds were involved, there's some matching state funds or state grants that are gonna pull this into it. So in that instance, yes, there's gonna be some push and pull, but I think there's a position to say yes. The retention should be 5% for those. Yeah, but to the extent that you're
I
not.
saw a contract yesterday, it still has 10, because all the GCs are still just using their template.
Their usual forms, right?
Exactly, and quite frankly, you also, especially for some smaller public entities, and one of the cases we'll talk about, I won't go into all the facts, but it involves a very, very small public entity. And a lot of those entities don't really pay attention, candidly, to some of these changes. They may not do a lot of projects. They recycle documents. They don't necessarily follow the requirements. There has to be a finding by the public entity to increase the withholding from 5%. So we occasionally see public entities who still have a 10% and haven't adjusted that. So it's always good to look at the documents. I will share on the private side, and I think Ken's absolutely right. We write a lot of letters for a lot of our contractor clients to try to push that percentage down. It would not surprise me to see that pop up to the extent we have and I say pop up, I mean the percentage staying closer to 10 if we are going to be hitting some leaner times on private projects where there is owner concern on contractor viability. And quite frankly, on the flip side, owners who are trying to keep more money because they may be having cash flow issues on their own. I would not be surprised if we're going to see a lot of owners continue on the private side to keep 10% just as a cushion given uncertainty in the climate.
Yeah, and with maybe a caveat of maybe reducing it to 5% at 50% completion or some threshold is kind of the compromise position that we see. So anyway, this is the law. So if you guys have public California, and this is for local districts, state agencies, this is what they're required to do. All right, as you know, obviously for retention on public works projects, there's the ability to have securities in lieu of retention. Contractors can get their interest at the end of the project on those. And this law, which is SB 1192, now expands that, but it expands to allow architects, engineers, surveyors, and project managers to also now do securities in lieu of retention when they're in direct contract with owners. Makes sense. All right, another change to the public contract code, which is the extension to 2029 of the CM at risk contracts for projects valued in excess of $1 million. Have you been involved in CM at risk contracts? Sort of. So there was a huge trend for that. About a decade ago, a lot of public entities were using that. So they had this one entity that basically was running and they were entering into different trade contracts, kind of a multi-prime type situation. And I think it's a little more disfavored because I think in the end of the day, the owners lack control. There just was more conflict with the CM at risk. So we haven't seen that as much. I think people will talk about gone much more to design build and other procurement methods. But nonetheless, this change in the public contract code for counties, and this is for counties, has extended the CM at risk of contracting. So if you see it, that's what this is. That's a lot of words here, guys. I can get the slide. I didn't put too many words on this one. But anyway, this is another change to the public contract code. And again, it's deals with design build.
Is this a slide or optometry?
It's both.
I'm trying to read what we typed in here. So anyway, this extends the law until 2025 to let public agencies, local public agencies, which includes counties, cities, school districts, et cetera, to use the design build procurement for certain projects with different thresholds. And I think the slide is pretty evident. One thing I will say, if you haven't really looked at the public contract code, it's broken out into different chapters or different numbers. When you see the change to a public contract code, it starts in the 200,000s, that deals with local public agencies. So that's not state agencies. State agencies is earlier. That's in the 10,000s. So when you see that change, that deals with other smaller, well, not smaller, but not state agencies, but definitely cities, counties, and local districts. So if you haven't done it, that gives you a little bit of a background. But anyway, again, public work, design build work is favored. I don't know if you guys do a lot of design build on public works projects. I think owners love it because it shifts the risk to the contractors and their design team. It can be more efficient. There can be a lot of integration with the designers and the contractors. And so I think this has been the trend, certainly over the last 5 to 6 years, to allow more and more projects to go design build on the public works side. And so this is an extension of that. All right, again, another change to the public contract code, and this again authorizes cities, counties, and other districts to use design build procurement for projects necessary to comply with accessibility in ADA. So if you guys are doing more specific projects that deal with ADA and other accessibility issues, this section now allows these entities to use design build, which makes a lot of sense because it's very design focused, design oriented. It's nice to have the integrated team. More public works, general services. So DGS, do you guys, any of you do work with the state DGS projects? Not really? Okay. Nonetheless, they are now allowing to use no bid contracting procedures for certain projects. Installation of carpet, resilient flooring, synthetic turf, and lighting fixtures. And so when we say no bid, that means they can negotiate on these types of projects. So if you're in these industries, there may be some expanded work for you.
No matter the size,
What's that?
no matter the size.
Yeah, there is no limitation on that, on size. So I think what they're trying to do is, a lot of those have to go quick. And so I think they're trying to speed up the process.
And so they're not even having to be listed on like a CMAS list of authorized contracts, right?
I think they still have to be DIR registered, and yeah, but I don't think there is a special list now for them.
And remember, that's not mandatory. It allows them, and like many state entities, DGS, others maybe, they'll use that, I think, as they deem appropriate, but how much, we don't know.
Well, obviously, a hot trend is affordable housing. There were lots of changes the last 2 years on ADUs, which I think some people have really taken advantage of. And then, so we have two different statutes here on this slide that deal with one, density bonus. I'm not even going to get into how we calculate that or what that means, but what it allows is just different percentages and what's required and to get, if you do that type of work, to get your density bonus. And then the other statute deals with ADUs, and they can now include a detached garage, and that qualifies as an ADU. So they're kind of expanding the definitions of ADUs, which I think, again, is the trend for folks.
Okay, and a few more. Going to talk a little bit about a couple pieces of legislation about everyone's favorite state board, the CSLB, I'm sure. I'm sure everyone's had a lot of fun interactions with them over the years. So I would say a pretty significant aspect of our construction practice focuses to one extent or another on licensing because of the penalties associated with doing work as an unlicensed contractor, whether it's actual or deemed. One of the first things whenever we have a client comes to us with an issue, we always validate and verify that their license status. When it's disputes with other contractors, validating their license status, just because the penalties and the impact to your ability to recover monies and criminal and economic impact of working as an unlicensed contractor are just so severe. That's one of the first things that we check off and look at on new matters all the time. And each year at CSLB, while there may be a lot of benign laws, CSLB is always making various tweaks, and they did so again this year. First one, AB 1747. So I think everyone here knows that the CSLB has some pretty harsh rights to enforce contracting requirements in California. And there's now a modification, an amendment to section 7110 of the Business and Professions Code that now allows as an identification of a willful and deliberate disregard or violation of building laws. A contractor who disregards any law relating to the issuance of a building permit. So that had been originally missing from that statute, which identified various aspects of California of public laws that may be the cause for disciplinary actions. It now brings in if there's any disregard of laws regarding building permits that may be grounds for discipline as well.
Yeah, and Greg asked the question, is there more, are certain agencies enforcing more? We haven't seen an uptick in the CSLB enforcement. I mean, typically complaints are made. They take their time. I mean, I think they care more about the residential projects and about people getting scammed. I think on the commercial side, we're not seeing as much of that. Sometimes if you're already in litigation, the CSLB will say, well, we're not going to get involved. You guys go litigate that, come back to us later. And it's not like the IRS where they want to hire 80,000. I guess they were going to hire 80,000 agents. We don't see the CSLB hiring more and more enforcement agents, which is probably a good thing for commercial contractors.
Correct. I will note that the provisions in the Business and Professions Code are not only applicable to the CSLB on enforcement. They may also provide grounds for damages and claims by public entities. To the extent there's a contractor working on a public project and there's evidence of violation of aspects of the license law as well. So just keep that in mind. Okay, another CSLB piece of legislation. This is AB 2916. And hopefully none of you in here, none of you who have tuned in have know what a letter of admonishment is from the CSLB. Have not received one. I hope you never do. But when there's a disciplinary proceeding and there's a complaint by the CSLB that is issued, there are various options it can take. Obviously, it may decide that the complaint's unfounded and find in the contractor's favor. There may be an adverse finding. There may also be a letter of admonishment, which is essentially saying, contractor, you have done these things wrong. You may have violated or you have violated laws. Essentially a slap on the wrist, but that stays with your license. And what this statute does is it allows that letter of admonishment to now, in certain circumstances, be published and accessible to anyone who wants to access the CSLB website or CSLB for up to 2 years. So, again, it's just one more of the penalties, if you will, that the CSLB puts in place when there's allegations of misconduct against a contractor. Yes.
So now if I go in and look at something, it'll tell me that there's been a violation or something else that I don't see the details. But this one here, will you actually be able to click and see a scan of the letter, or is it still just misstated?
I don't know whether you'll be able to access the letter directly from clicking on the website. I believe you will, because you can access complaints on the website as well. And there's disclaimer language when there's a complaint that's been inserted. I believe you will be able to access, whether it's directly through the license page or from another link, but they will make the admonishment letters accessible.
Yeah, and a little trick is if you can't get it online, you can serve a public records act request and CSLB asking, and they have to, unless there's some privilege or other reason, they have to actually produce that to you. So you can get that anyway if you're that interested.
Right. Oh, let me go back. Sorry. So, and I think the last piece of legislation we're going to talk about, this is SB 216, also a CSLB legislation. And this is actually a significant one. And this also arose out of a lot of litigation and claims that have arisen from the contracting licensure requirements. And I had mentioned before, one of the things on intake that we look at is a license status of not only our clients, but contractors that may be in dispute with our clients as well. But the fact that there may be, you click on the CSLB website or you get a certified licensed history and says licensed the entire time, no gaps in license, no disciplinary action, doesn't necessarily mean that could not ultimately be a finding that the contractor wasn't licensed. And one of the very serious issues that arise that we see are contractors over time who have represented the CSLB, they have no employees, hence that they don't need workers' compensation insurance, yet they do have employees. And there have been a number of cases that have come down, some published, many not, where there have been determinations by courts that a contractor who has employees, deemed to have employees, doesn't have workers' compensation, is going to be deemed unlicensed.
Is there an insurance person in the house? So if you try to say you don't have any employees, what are you actually providing coverage for?
Yeah.
Or how would that possibly work?
My assumption, I did work comp for 9 years, it's probably due to the fact there's a lot of undocumented workers that they're trying to protect, because regardless of their status, they are entitled to work comp benefits. That's my guess, I don't know.
Yeah, that's a good question.
Yeah.
Looking at this, you're like, well, they have no employees, but it would cover folks.
Yeah.
Exactly. And I think this is, the CSLB's acknowledgement that they would probably take the position that circumstances change over time. So I think jumping ahead to what this law does, essentially says that until 2020, through 2026, only certain specialty license holders, so C8, C20s, C22s, and D49. So that's HVAC, asbestos abatement, and tree service, and also.
Didn't roofing already have this come into play?
Yeah, they did. And I think part of that was to your point, as far as maybe undocumented workers, kind of just given the nature and scope of that trade. And I think if you take a step back and you just look at those trades, roofing as well, how can you actually do that work without having, some labor force that you would be responsible for? And obviously, one of the downsides as well is, remember how that impact flows through. If you're a contractor, you're deemed unlicensed, you have for the insurance folks in the room, and you have a catastrophic injury, and a contractor's deemed unlicensed, guess what? The owner is going to get hit for that, even if they have absolutely nothing to do with the circumstances that may have resulted in that catastrophic injury. So, there's a lot of ripples from it. So I think this is the legislature's intent to attempt to,
Protect the consumer.
Yeah, it would protect the consumer, but really, get a reality check as far as, a few of the bad apple contractors out there. But the legislation goes further. So starting in 2026, all contractors are going to need to have workers' compensation, regardless of what the classification is. So this issue is going to eventually be going away. The only carve out, and I'm sure over time there'll be a few additional carve outs through certifications. One of them is if there's a joint venture between two contractors, and there's a certification that's provided as well. So it's going to be evolving, but just know that as we move forward, more and more trying to exempt or accept yourself from workers' compensation, if you're a very small specialty contractor, that's eventually going to go away.
So how
Yes.
will this affect the WCIRB and all of the XMOD rating and all that?
We'll take that over to the insurance professionals. That's what lawyers do. Talking to insurance.
Impact on them, I would think.
I apologize, I didn't hear the question.
I was thinking, like, how is this gonna impact the XMOD and the WCIRB and how all of that?
I mean, as far as Exmon and the WCRB, they have to generate enough payroll to even get them on.
That's true.
Doesn't mean they're gonna report
I
it,
forgot
they're
about
reporting it anyway.
They'll say minimum premium about 1,000 and never get them.
That's why roofing is all, they're all, state fund, don't report that.
And the GCs in the room or online should be pleased with this, because If they have the subcontractors and these classifications working for them without coverage, GC is gonna be held responsible for the injury to the employee that there's no workers' compensation.
All right, so that's the summary of the construction law changes for the year. As we said, nothing earth shattering. Well, I think the last one is pretty significant for most of the folks in this room, for sure.
What we'll do, before we move on, any questions either online or here on legislative changes?
It's crystal clear.
Yeah.
You read the statutes, you're gonna read them at night or put to sleep. Yeah. We're gonna talk about that. Read a contract or read statutes. One's gonna put you to sleep faster, so. Okay. So let's talk about, there's 4 cases that came down in the construction law that we want to talk about that came down in 2022, and these were appellate court decisions. And the first one, and actually it's a really nice segue, is a license law case. Go figure. There's always license law cases. So as Scott alluded to, if you're unlicensed, there's really draconian penalties that are going to apply to you. And in the Business Professions Code, section 7031A, if you're unlicensed, you're not entitled to get compensated for the work you did on a project. And the law is pretty clear. You can be unlicensed for a day, 2 days, 3 days on a long project, and you get 0 for the entire project. Okay? It is absolutely, in the construction world, the most draconian law that we see. And hence why, as construction lawyers, we always look at licensure. There's also another element to that, which is 7031B, that if you do work and you get paid and you're unlicensed, the entity that paid you can disgorge or take back the money that they paid you. Okay, so if you get letters from the CSLB, you have any questions, and now the workers' comp is going to be an issue here, better jump on that immediately. You cannot let your license lapse for a day. So let's keep, that's our scare. Now let's talk about this case, the Kim case. And the Kim case was a tree trimming case. And basically, the sub who did the tree trimming was unlicensed. And then the general contractor tried to receive compensation from the owner for the work of the unlicensed sub. Well, the court looked at this and said, that the intent of the law is the unlicensed contractor is not going to get paid. So in the end, what the court of appeal here said is the general contractor cannot get paid for the work of his unlicensed sub. Makes sense.
But only that portion of the contract.
Only that portion of the contract. So that's a really interesting point in that there's arguments of if a general contractor uses unlicensed subs, is the general contractor going to be deemed to be unlicensed because they're not fully compliant? I haven't seen anything that says that yet. Lawyers have made that argument. I haven't seen an appellate court case on that. So we've got to be careful. So when you're a general contractor and you have an unlicensed sub, well, first, you're probably going to terminate them because they're not compliant, but you got to be careful there. And just like Scott indicated, the whole workers' comp issue too.
Yeah.
You can be deemed unlicensed if you don't have adequate workers' comp. So it's just, the law is, and again, the law is there to really protect, I would say, more homeowner types, but it applies to all projects. Okay, so just again, this is, I think, just another example of where the courts are enforcing what the intent is of the license laws.
So how does a GC protect themselves on a 2-year school job and they've got 50 subs and they've got 2 second and third tier subs, and what do you check every day? I mean, you have a license for.
I would throw it out to the generals. I would say almost every month you've got to, maybe not daily, but maybe monthly, you're checking the licensure.
Holy crap. And if it lapses for 1 day.
Well, that sub
That
sub is going to be unlicensed, and the question is, are you not going to get compensated? Now, you don't have to,
But it's not gonna be.
you don't have to pay downstream.
Yeah, cool.
Yeah, I mean, that's a lot of responsibility on the GC, and not only, labor law now kind of being thrown onto the GC.
It's tough to be a GC.
Now you can.
Some don't want to hear it, but it's tough to be a GC. Yeah, there's a lot of, you have to, a lot of administrative work to stay on top of that, just like prevailing wage too, right? It's, you have ultimate liability as a general contractor. You got to make sure.
Right. Well, and that's, look, it's like, as a GC, you have to have that line of demarcation. At some point, there's gonna be trades that are so minimal that you're just gonna have to, you may not be monitoring as much, but for your MEP, for your bigger trades, whether that's, bonding those, or focusing on those just to make sure that you don't have any, there's no surprises, because I will share with you, there are many, many large contractors that you would be surprised have oopsies because, somebody forgets to submit, an insurance renewal, they forget to submit some documentation in the CSLB for a couple of days. Or the CSLB is behind, as we all know, in processing, so things aren't shown. But there are large contractors who do have those whoopsies. We have a certain consultant that we use, that we bring in to assist in those instances, to address those issues as they come up, and to work with, because that could be significant. If you have a large MEP who may have been, a week goes by in the midst of a large project that may be deemed unlicensed because of a delay in submitting an insurance renewal. It happens.
Will
believe it or
body
not.
pack a sub cover that?
Yeah.
So that subs.
Yeah, bonding will help.
Yeah.
Performance, payment, oh, what do you
Performance one.
Yeah,
Okay.
that would help. But it's,
Guarantees the contract, right?
yeah, it's a tough one.
Exactly.
It's a tough one.
Okay. And it goes to sub-selection.
All right. Second case we'll talk about is a ranked repair act, SB 800. People do residential construction, crack homes. The right to repair act is the codes that deal with the dispute resolution mechanism for those types of projects. And what it does is it defines what a construction defect is. And then it has all sorts of pre-litigation requirements in terms of exchange of documents, got to give the contractor the right to an opportunity to repair, mediation. It came down 20 years, 15 years ago, I'm dating myself, to try to head off the construction defect litigation, and I will tell you, it has not. But nonetheless, it's still the law and you still have to comply. So all this case did was expanded the definition of what a defect is for roofs. And I'm not going to bore you with all the details, but if you're involved in a construction defect, home litigation or mass home litigation, and there's roof issues, this case you need to look at, see if it's within a repair.
Okay, a couple other cases, and then we will break, and it will be Aaron's turn to scare you on the employment updates for the year. This is a fun case. We'll get to kind of the intent and the holding of this in a minute, but the Clark Brothers is North Edwards Water District. And for any of you who have driven from Bakersfield or LA to Vegas and go through the Mojave, past Edwards Air Force Base, and this little water district, North Edwards. And I mentioned earlier, with one of the pieces of legislation, you have a lot of very small public entities that do a lot of dumb things. Well, this is one of them. There's this water district. It's like 200 people it serves. They have one employee. And the facts in this case, if you ever have a chance, Google it, read it, your jaw will drop. It's astounding. I mean, it's self-dealing. It's real, the one employee who had a relationship that they required the contractor to warehouse their materials and to store their equipment on a lot that was owned by the boyfriend of the one employee next door. I mean, all kinds of crazy stuff. So it's awesome facts. And it really comes down to, and by the way, the water in the district is like some of the worst in the state. It has like every carcinogen in the world. And the project was to make the water drinkable. And in the board meetings, all the board members said, we don't drink our own water. I don't know what's going on. So absolutely crazy. But this case is important for a one very significant reason that is going to impact most contractors. I think all of you are aware of prompt payment penalties. There's obligations on generals to pay down subs monies. There's also obligations for owners and public owners to pay generals on time. And under Public Contract Code 20104.5 for progress payments, a local public agency has 30 days after getting an undisputed and properly substantiated pay application to make payment. Well, what the court held was that a public entity's failure to promptly pay is not a breach of contract. That they may have violated a statute, but that's not a violation or a breach of the contract. There may be a breach if the public entity doesn't pay the penalty, the interest associated with that. But the fact that a public entity elects to pay late is not in and of itself a breach of contract. And we have many clients contractor clients who come in and say, oh, it's, they're breaching the contract. I want to walk off because they're not paying me on time. Well, okay, you got to slow that roll a little bit because that's a business decision, maybe a bad one, that the public entity is making as far as timing of payment. So just remember that if you're a general or if you're a sub and you know that the public entity is paying late, may not be a breach of contract, but make sure that you are pushing for those penalties and for the interest associated with it.
Yeah, just real quick, when you have a lawsuit and you're seeking prompt payment penalties, you want to sue for breach of contract. Although this case doesn't help you. We also have a separate cause of action for violation of the prompt payment statutes. So that's how you cover yourself. It's trying to get the statutory interest plus attorney's fees if you can. So you do want to break those out. Yeah.
Okay, perfect.
Yes.
I have a question from one of our online attendees. Why isn't SB 800 used more often to prevent litigation?
So it is used for those cases.
Okay.
I mean, for the whole, it's only for certain types of projects. With mass homes, I think it's affordable homes. And you're required to use it. You're required to go through the process. A lot of times people just check the box.
And it is complicated.
And so you'll see it. People don't comply. Sometimes they're up against certain statute of limitations they're worried about. So they're supposed to follow it. And if the owners don't follow it, there are some penalties that are assessed to that, and they may be barred from certain claims. So technically, if the project's covered, they're supposed to go through that process. I just haven't found that it's resolved matters.
Okay.
I think because you're talking about 100 home subdivision, typically that's going to go into litigation. Right?
And it's very much, again, lawyers in the legislature who are trying to legislate a certain result and think, oh, this is going to help resolve issues. Well, I would liken it a lot to Public Contract Code 9204, exact same thing with respect to public contracts. The intent there was, outside the realm of residential construction, but asserting claims during project. If there's change order disputes or other claims, it hasn't resulted in anything but just more paper pushing and paper shuffling between contractors and public entities. It really hasn't helped anything. Last case before we take a break, another oopsie that we deal with occasionally. This is the Pantera GP Inc. Versus Kern County Superior Court case. So in this case, you essentially had an entity, I'll just call it Pantera GP, was a general partner of Pantera Development, was the LLP. The work was on this, it was a movie theater remodel, and the owner intended to have Pantera GP, was a licensed contractor, perform the work, but when it prepared the contract, it accidentally put Pantera Development as the contractor, which is not licensed, but related. And as you may imagine, Pantera does the work, and the owner says, hey, I don't have to pay you, you're not licensed. Pantera Development, you're not licensed. So they went round and round with lots of pleading motions and issues, and actually the trial court held in favor that yes, Pantera Development's not licensed. Court of Appeal got that reversed and essentially said, look, that was a mistake between the parties. Everyone knew that it was the Pantera GP, the licensed entity, that was going to do the work. And so the court actually reformed the contract to correct the mistake of the parties. But the court was very careful to say that this was very fact specific, and that that not in every instance the court may not deem that this was a mistake of the parties, and if there was any involvement by the party who was actually identified as the contractor, there could be some significant issues. So again, I think the takeaway on this case, be very careful in your contracts. On the private side, make sure that when you have, you have related entities, maybe very close in name, make sure you have the right entity. And if you identify that there's an issue, correct it along the way, because especially in the economic climate we're in, you may have owners who may try to take advantage of that, as this owner tried to get $3 million worth of work for nothing.
Scott, how much, like how literal, like if you are ABC contractor, comma LLP, and it writes out LLC, or, commas, not commas, LPs versus LLCs, inks.
It could be, very good question, right? That you would think if it's just a missing comma, or maybe there's a capitalization that is or isn't there, that's in the formal name, you'd think it shouldn't make a difference, and it very well may not, based on this court holding. However, if it's a common name for an entity, for those who, if you have a sewer issue, or you have an appliance issue, and you look in you do a Google search and it's, AAA appliance or AAA appliance, if it's a subtle difference, it may have a huge issue. It could be a factual issue. So, again, the takeaway, just make sure you get the right entity identified in the contract.
Make sure like you have a sub, it matches what's on the license board.
Right.
So that's important.
I had a contractor try to protest the bid, and it was Campbell, the legal name is Campbell Construction Co. And the agent put Campbell Construction Company.
Right.
And, and the owner, like, come on.
Well, and we do see occasionally, especially, a good point on sublisting protests, there will be, especially in larger markets, if you're LA or the Bay Area, Smith Electric, or, Rogers Plumbing, but you look it up and there's 4 of them in the area, especially if rather than a particular city, they just put SF or LA.
And that's why the bidding laws changed, right? You
Yeah,
put the license number down, so
Correct.
it got away from this,
Yeah.
which Smith are we talking about? Right, location, so they kind of cleaned that up.
Try to, but it happens occasionally.
What about DBA versus legal name? I mean, is there a best practice on that?
If you are licensed, if you have a DBA, you should have that in your license name, and you should be consistent.
Well, but if it is in your license, let's say we're OWR Mechanical and Monarch,
Right.
does it make a difference how the GC presents it on the contract
I would think you want your full name on there with the DBA.
with the DBA?
Yeah, because that's the license name.
Right, and your license number.
The
as well.
license says it has the DBA. as
Right,
well.
right. So I think it should be
Well-
consistent. Now, it's not going to bar you necessarily because technically the legal entity is not the DBA. But again, it's good on the, because it's the corporation name, but it's good to have that just because of the licensure issues too.
Tagging on Ken's earlier response to Greg, and it was about 20 years ago, we saw a client, but they submitted their bid with the name style as it is with the Secretary of State, but the license board doesn't have commas and periods. Their bid was protested and it got kicked out. And so for that particular contractor, it does not have comma, it does not have period. We go by what our client tells us to put for their names. And anyway.
It's crazy. It is.
Well, I think we're almost running up against it in time. Do we have time for a question or two now? We can save the questions at the end as well, but anyone have any questions here or online they want to raise before we take a quick break?
Generally speaking, when does a suspended project turn into a terminated project?
Okay. Well, stay a little bit later.
Just like retention, we had a project that was terminated early on and we haven't been paid retention. Like at what point, is it indefinite or?
Well, and that's what we'll have to talk about that, David, because if you have a suspended project, it may start to trigger lien rights and lien times. If there's a cessation of labor for 60 days.
Uh-huh.
So you gotta be worried
So
about
there's
that.
no it just seems like you could say it's suspended forever, right?
It's fact specific. Yeah, extremely fact specific. As Ken said, you
Going on with the retention.
Yeah, you walk into definitions of when acceptance occurs because of cessation of labor and completion.
A couple minutes and then. Bye.
Yeah.